roads, a citizen cannot approach the court and seek the construction of a road to enforce the right to move freely. The opinion of my learned brother fails to have noted the judgment of a three-judge bench of this court in state of Himachal Pradesh versus Umed Ram Sharma. I'll not read the rest of that. Contrary to what is stated in the judgment of Bhadje, the directions in my judgment do not require the state to create a social or legal status or a social institution. The directions are with a view to recognizing the choice that a person makes for themselves when they choose another to be their partner for life. The directions seek to make that choice a meaningful one. Nowhere do they create an institution of any kind. Rather, they give effect to the fundamental rights in Part 3 of the Constitution. This is the mandate of this court under Article 32, which says that the Supreme Court shall have the power to issue directions or orders or writs for the enforcement of any of the rights conferred by this part. No response is forthcoming to my detailed exposition of the scope of the powers of this court under Article 32. In section D1 of my judgment. In fact, Justice Bhatt himself recognized that courts often enable and oblige the state to take measures. My learned brother also arrives at the conclusion that the state is indirectly discriminating against the queer community, but fails to exercise the power vested in this court by Article 32 to alleviate this discrimination in any way. This court is not through judicial diktat creating a legal regime exclusively for persons of the queer community, but merely recognizing the duty of the state to recognize the entitlements flowing from exercising the right to choose a life partner. Page 234. The judgment of my learned brother contradicts itself when he holds that the SMA is not discriminatory by relying on its object on the one hand, and that the state has indirectly discriminated against the queer community because it is the effect and not the object which is relevant on the other. My learned brother discusses in detail the deprivation, exclusion, and discrimination faced by the queer community. In effect, he firstly recognizes that they have a right not to be discriminated against, and secondly holds that the actions of the state have the effect of discriminating against them. However, he does not take the step which logically flows from such a ruling, which is to pass directions to obviate such discrimination and ensure the realization of the rights of the queer community. I cannot bring myself to agree with this approach. The realization of a right is effectuated when there is a remedy available to enforce it. The principle of ubi jus, ibi remedium, that is, an infringement of a right has a remedy, which has been applied in the context of civil law for centuries, cannot be ignored in the constitutional context. Absent the grant of remedies, the formulation of doctrines is no more than judicial platitudes. In view of the deeming fiction created by Section 12 of the Hindu Adoptions and Maintenance Act 1956 and Section 63 of the JJ Act, an adopted child is a legitimate child of the adopting couple. The manner of determination of legitimacy prescribed by Section 112 of the Indian Evidence Act shall not apply in view of the deeming fiction created by Section 12 of the Hindu Adoptions and Maintenance Act and Section 63 of the JJ Act. Thus, all the benefits which are available under the law to a legitimate child who has been validly adopted of a married couple will equally be available to the legitimate child of an unmarried couple. For example, Section 20 of the Hindu Adoptions Act, which provides that a Hindu is to maintain their children, does not make any distinction between a legitimate child of a married and unmarried couple. Similarly, succession law in India does not differentiate between the child of a married and unmarried couple if the child has been adopted by following the due process of law. Further, the breakdown of the relationship of an unmarried couple will not lead to a change in applicable law, because the child will continue to be a legitimate child even after the breakdown of the relationship. It is therefore unclear what the disastrous consequences referred to are. My learned brother has also failed to address whether Regulation 5.3 is discriminatory for distinguishing between married and unmarried couples for the purpose of adoption and for the disproportionate impact that it has on the members of the queer community, while simultaneously holding that the state cannot on any account make regulations that are facially or indirectly discriminatory on the ground of sexual orientation. Now I'll pronounce my directions. The first part of my directions are directions to obviate discrimination. Counsel for the petitioners and some counsel for the respondents advanced extensive submissions on the various forms of violence and discrimination that society and the state machinery inflict upon the queer community, and especially queer couples. This has been discussed in detail in the prefatory part of the judgment. Counsel sought directions to obviate such violence and discrimination. Now, my directions. A. The union government, state governments, and governments of union territories are directed to 1. Ensure that the queer community is not discriminated against because of their gender identity or sexual orientation. 2. Ensure that there is no discrimination in access to goods and services to the queer community which are available to the public. 3. Take steps to sensitize the public